Yes. So let's begin the session for the day.
Okay, sir.
So I'd like to introduce our speaker for the day, Justice Paranthaman, former Judge, Madras High Court. It is an honor to introduce him in our forum for the second time. Earlier, he had spoke in our forum in a workshop with the theme of secularism in India. So his journey is truly inspirational. He was the first fortunate child in his family to attend primary school. His educational journey began in Kondancherry and led him to Konditop, a predominantly labor area in Chennai, in search of a free school. With the support of his aunt, he was accepted into a school with a free hostel facility, which became his second home. He was an excellent student. He completed his post-graduation in mathematics from A.M. Jain College. Originally aspiring to become a teacher to work with living objects rather than machines, the emergency period transformed him into a social activist. His interaction with late comrade Radhakrishnan, who was a hostel mate, stirred him away from his teaching ambitions and motivated him to study law to aid the poor and needy. As a student at Madras Law College, he actively engaged in activism, which instilled in him profound commitment to the cause of marginalized and weaker sections of Indian society. So he began his legal career under the mentorship of Mr. Senthilnathan, a labor law practitioner who accepted him as his first junior. This experience was foundational to his career. He later moved to the office of Mr. M. Venkatraman, senior advocate practicing criminal law. Although he longed to join the office of Mr. N.G.R. Prasad, he couldn't do so. Instead he became an Ekalaiva. So throughout his career, he used law as a tool to uplift the poor, the underprivileged, and the disabled. So we are very happy and proud to have you on our forum, sir. The forum is yours.
Thank you, Mr. Subramani. And the data, which I think I gave 5 years ago, you have preserved. you have introduced you introduced meticulously with the data, with those data. And earlier, the topic that was assigned to me was secularism. And it was very familiar to me. As far as this topic is concerned, the child right is concerned. I put it child rights. Whatever is that topic, it is relating to child or child right. It is a new, not as a lawyer or even as a law student. There was no legislation when I did law relating to child. And also, even as a lawyer, I had no occasion to practice, because even those legislations, now I will refer to, are later legislations. And we are very late. Our response was belated. And though our constitution refers to child specifically at so many places, I will begin my speech with the constitution, because we let us understand the constitutional background of a child's right. The constitution refers, I think most of the audience are persons related to law. Therefore, I treat this as sessions dealing with something like law student and lawyers. And the various articles where child is specifically used, I want to mention only those articles. Those articles are I will deal with also those articles subsequently. Article 15(3) of the Constitution, Article 21A, I don't want to repeat Constitution. Article 21A, Article 24. I just want to also say what those articles says. Otherwise, it has no meaning. Article 39E and Article 39F. Article 45 and Article 51 capital A small k. 51AK. These are all the articles where the child or children are referred to in the article itself. And apart from this, I need not tell other articles also, wherever a fundamental rights is guaranteed to a citizen or a person. Article 21 uses person, Article 14 uses person. That will also cover child. Apart from that, the child is specifically used in these articles, the above mentioned articles. Let me take first 15.3. We know about 15. Article 15 is prohibition of discrimination by state on grounds of religion, race, caste, sex, or place of birth. That is the concept of Article 15. But Article 15.3, it is like an exception. It says state shall, nothing in this article shall prevent the state from making any special provision for women and children. We are not dealing with women, children. Therefore, Constitution rests on the state to make laws in favor of children because they require such a protection from the state. And next is Article 21 capital A, introduced in 2001 or 2002, the right to education up to 14 years, 6 to 14 years. And still it is not a compulsory. In my view, I have my criticism, I'm not, but it is a step forward. Because before that, it was not a fundamental right. Now it is a fundamental right. Of course, it is not a compulsory free. It is not made free because private players are also permitted. The state shall provide free and compulsory education to all children of the age of 6 to 14 years. If they stop at that level, then it will be a mandate, compulsory education. But in such a manner as the state may by law determine. That is only right to RTE, Right to Education Act. Of course, it is a welcome measure because capital A means it was not enacted when in 1950 when it came into effect. It was amended 21A in 2001 or 2002. Then I said Article 24 is the next. I said Article 24. 24. All these articles 15A, 21, 15.3, 21A, and 24 all appear in the part 3 of the Constitution, namely fundamental rights. 24 is prohibition of employment of children in factories, etc. No child below the age of 14 years. Therefore, it is a constitutional mandate. Shall be employed. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. But we know, but practically the children are employed in factories and fireworks manufacturing or BD rolling. Or you can step out of our house, you can meet the children are involved in vending. Even for you see burning the papers, that paper, the paper boy, newspaper morning, even sometimes they are 14 or 15 years of child. And these are all the fundamental rights. Then 39E of Constitution, the state, it is a directive principles that the health and strength of workers, men and women thereafter, and the tender age of children. This portion, tender age of children, are not abused, and that citizens are not forced by economic necessity to enter a vocation unsuited to their age or strength. That is our directive principle. Then 39F, that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and the childhood and youth are protected against exploitation and against moral and material abandonment. I hope these are I request you to look into these the provisions of the Constitution subsequently in detail. That is why my idea is only it is giving a bad eye view. Then Article 45 of the Constitution. It is relating to 1 to 6, up to 6 years of age. The state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. That is 45. Then 51AK is a fundamental duties. That is a later addition in the Constitution. Who is a parent or guardian to provide opportunities for education to his child, or as the case may be, what between the age of 6 and 14. It is a fundamental duties to impart education on the children. These are all the constitutional provisions. They directly deal with the children. As I stated, I repeat, other articles, those articles are also very much relevant, like Article 21 and other Article 19. Those articles are also very much relevant to the child. And in any event, these are all the articles where it directly refers the child or children in the Constitution. Then in my view, the major legislation relating to child is the Juvenile Justice Care and Protection of Children, within bracket. The Juvenile Justice Act 2015, after Justice, Juvenile Justice Care and Protection of Children Act 2015 is the major legislation concerned with the children, in my view. I like every one of you to look into those the provisions, study the act, study this legislation. Yeah, it's a comprehensive legislation, and this the earlier the legislation that was in operation was in 2000. The Juvenile Justice Care and Protection of Children Act 2000 was there. That was repealed by this act. But either in 2000 or by this act, why this statute was enacted? I think it is very useful to refer to the objects and reasons stated by the Parliament while enacting the law. That is very important. I just to read the top 4-5 lines. I leave it. Whereas the provisions of the Constitution confer powers and impose duties under Class 3 of Article 15, Class C and F of Article 39 and 45 and 47. In fact, 47 does not refer to child straight away, but 47 also they refer to. What Article 47 says is, duty of state to raise the level of nutrition and standard of living and to improve the public health. Therefore, it is not directly deal with the children, but however, the object and reason says, whereas the provisions of the Constitution confer powers and duties under Class 3, Subclass 3 of Article 15, Class E and F of Article 39, and Article 45, Article 47 on the state to ensure that all the needs of children are met and their basic human rights are fully protected. And whereas the government of India, this is very important, you see, as acceded on 11th December 1992 to the Convention on the Rights of Child adopted by the General Assembly of United Nations. You kindly see, 1992. What is the response? that we acceded to, but our legislation is after 8 years. We are party to, we agreed to. Not that in every General Assembly, these resolutions, we acceded. Here we acceded, which has prescribed a set of standards to be adhered to by all state parties in securing the best interest of the child. And whereas it is expedient to reenact the Juvenile Justice, Care and Protection of Children Act 2000 to make comprehensive provision for children alleged and found to be in conflict with the law. I will deal with this. And children in need of care and protection. There are two things. Yeah, the purpose of the act is to deal with the children who are in conflict with the law and children in need of care and protection. What is taking into consideration, one, the standards prescribed in the Convention on the Rights of the Child. Two, the United Nations Standard Minimum Rules for the Administration of Juvenile Justice, 1985, namely the Beijing Rules. 2. 3. The United Nations Rules for the Protection of Juveniles Deprived of Their Liberty, 1990. The Hague Convention on Protection of Children and Cooperation in respect of inter-country adoption, 1993. Therefore, and other related international instruments. Be it enacted by Parliament, that is how it has been narrated in the statement of objects and reasons. There are, in my view, broadly, there are three legislations. One is this act. I think this is I will deal most part of my time. I will take about 45 minutes to 1 hour. The most part of time it will be allotted to this act. This is I think the most important legislation relating to children. Number 2 is you all know POCSO Act, the Protection of Children from Sexual Offences Act 2012. It is much belated. Here the Juvenile Justice Act was 2000. That was repealed and reenacted in 2015. It is 2012 is a very latest origin. While I was serving as a judge, POCSO Act is 2012. Yet another act is 2005 Act. That is the commission. 1 minute. That the act is called. Wait for a minute. Is Commissions for Protection of Child Rights Act 2005. Commissions for Protection of Child, but practically that does not give. It is like a CST commission or basic backward class commission. It's a statutory commission. Earlier also it was statutory commission. Now those commissions were given a constitutional basis. Here it is a statutory commission. They will make recommendations on the child welfare. It's a central commission, state commission, and they contemplate about setting of special courts that they called the children's court. This act called those courts are children's court. These are all the three acts. I am not going to deal with commissions for protection of Civil Rights Act 2005. In my view, it is only commission. It's only recommendations. And these two acts are about adjudication and litigation. One is the Juvenile Justice Act 2015, or if you want to read it fully, Juvenile Justice within bracket Care and Protection of Children. Act 2015. Next is the Protection of Children from Sexual Offences Act 2012. First, I take Juvenile Justice Act. I read the objects and reason. And really, it is very exhaustive. I think lawyers practicing. You see, the section 2 deals with normally definition class. There are 61 definitions, 2:1 to 261. I'm not going to read those definitions. Kindly you look into it. And for instance, I just want to say, first, what is child in
Sir, your voice is breaking.
Use the word, they don't but it is really a conflict with the law. And also apart from that, there are there may be there are also, you see, children also, child, the child is defined in the Act 212 define the child who has not completed 18 years of age. That is the definition of the child. And all the acts, it is below 18 years of age is a child. And you also let us see that the three definitions is one is what are the petty offense? What the child in conflict law commit offense? It is a petty offense. Then what is the petty offense? The punishment provided is up to 3 years, but it is not for the child. I'm not. It's totally different. What is the petty offense? There is up to 3 years. What is the serious offense? There is a secondary serious offense. Serious offense is up to generally. There is a second portion. Let us for easy understanding up to 7 years. That the heinous crimes is 7 years and more. Is a heinous offences. And for care and protection. What is a care need? A child in need of care and protection is defined in section 214. The child in need of care and protection means a child. I just want to read. Who is found without any home or settled place of abode and without any ostensible means of subsistence. 2, who is found working in contravention of labor laws. I am not reading entire thing. Who resides with a person, whether a guardian or child or not, and such a person, injured, exploited, abused, neglected the child, or has violated any other law for the time being in force meant for the protection of child, or
Participants, I think there's a bit of a connection issue. He'll be back in a moment. Participants are requested to be patient. Thank you.
sir, I am connected with my cell phone. There is a
Yes,
call
sir.
that ended in disconnection. Sorry,
Okay, sir.
the
Okay, no
child
problem.
in need. I was dealing with the child in need of care and protection. That it means a child who is found without any home, who is found working in contravention of labor laws, who resides with a person, and such person has injured, exploited, abused. A. B. Has threatened to kill, injure, exploit, or abuse the child. I'm not reading fully. C. Who has killed, abused, neglected, or exploited. These are the 3. 4. Who is mentally ill. Or 5. who has a parent or guardian, and such parent or guardian is found to be unfit by the committee or the board. I will tell what is the committee, what is the board under the Act. 6, who does not have parents and no one is willing to take care of and protect, or who is abandoned or surrendered. Who is 7, who is missing or a runaway child. 8, who has been or is likely to abuse, tortured, exploited. It goes on up to 12. These are all the two. It is a very relevant definition. Only I said child in need of care and protection. The word that, as I said, the title of the law is Juvenile Justice within Care and Protection of Children Act. That's the care and protection. The act deals with the care and protection of the child. And there are two bodies are very important. One is Child Welfare Committee. Is a important body. The committee is a word used wherever committee. I also said about the committee. The committee is defined under 222 means Child Welfare Committee constituted under Section 27. I think this is a most the important body dealing with the children's rights. Number 2 is the board that the Juvenile Justice Board. Board means Juvenile Justice Board. It is nothing but a court. It is nothing but a court. Therefore, these two are most important the bodies created under this act. Third is the special court, children's court, which I will come later. These, but the major responsibilities are these two bodies do a lot of services, lot of work under this legislation. And let me go to I am not going to deal with. There are totally one on 2 sections. I am not going to deal with all the sections, but in my view, there are certain chapters are most relevant. In my view, the chapter 2, 3, and 4 are relating to both. 2, 3 are both 2, 3, and 4. Chapter 2, chapter 3, chapter 4 are relating to Juvenile Justice Board. I think this is an important portion of this act. From section 3 to section, I think 38. 3 to 26. 3 to 26. It is put in chapter 2, chapter 3, chapter 4, dealing with Juvenile Justice Board. Then Child Welfare Committee is chapter 5 from section 27 and chapter 6 from 31 to 38. I think these chapters are very, very relevant, and one has to read to understand what are all the rights of child rights. This chapter. And part 3 of the Constitution, if you one has to definitely read fundamental rights in the Constitution, like this chapter 2 about the chapter 2 simply says what is the general principles of care and protection of children. Well, we have already stated about care and protection of children. That is defined under just now I read under 214. I don't want to repeat. Care and protection is given in a very lengthy definition. And here, what is the general principle to be followed in the general principles of care and protection? Section 3 deals with 1 to 16 principles, basic principles governing this legislation. I am not going to deal with that, but I just refer to one. One is the presumption of innocence. A child is presumed to be innocent, and right to participate is I'm not that it is every child have a right to be heard and participate in all process, and I am not. I want to use a word, one right to participate. and the principles of best interest of a child. The primary responsibility is a family is the primary responsibility. Even the statute contemplates the responsibility is the primary responsibility. I don't want to read every principle. I want to read one important principle is non-waiver of right. Principle of non-waiver of right. I want to read this. No waiver of any right of child is permissible or valid by the child or person acting on behalf of the child or a board. What is a board? Juvenile Justice Board. That is a court. Or a committee. Children Welfare Committee. Child Welfare Committee. And any non-exercise of fundamental right shall not amount to waiver. Therefore, there is no question of waiver of any right by anyone. These rights are absolute, children's rights. That I just so non-stigmatizing semantics, and so it and the past records, the principle of fresh start. All past records of any child under justice juvenile system should be erased, except in special circumstances, except in the heinous crime. All other records will be destroyed. That is what the Act says. These are all the principles. I just chapter 2 contains only one section, section 3. It has 18 classes. I'm not 16 classes. 16 classes. A few of the classes I refer to, like principle of non-waiver and the principle of participation and the principle of family responsibility, principle of best interest, presumption of innocence. Only 5-6 I just referred to. There are 16 principles. It deals with only one section, section 3. Then next is what is Juvenile Justice Board? Juvenile Justice Board is a court. It is a light court. In fact, it consists of the totally 3 members. One among them is a metropolitan magistrate or a judicial magistrate. You know, in Madras city, the post is called the metropolitan magistrate, the lowest bottom in criminal justice system. Other than metropolitan city, it is a judicial magistrate. The Act called them, the common name is principal magistrate. A magistrate at least with 3 years of experience. A magistrate should have at least 3 years of experience, will be appointed as will be appointed as a part of board, Juvenile Justice Board, along with the 2 social workers. And one among the social workers shall be women. This is the constitution of the board. Board means a Juvenile Justice Board. Wherever I refer board, it is Juvenile Justice Board. It is a court. The 3 member, totally 3 member. The principal magistrate is from judiciary. There are 2 social workers. One among them is a woman. And what is the qualification? The qualification is, as far as magistrate is concerned, we know he is a magistrate. He is recruited by the Tamil Nadu Public Service Commission along with the High Court. And he should have 3 years experience. He is appointed to hold the office. Now, as far as the social worker is concerned, the education is the person should actively involved in health, education, or welfare activities pertaining to children at least for 7 years, or a practicing professional with a degree in psychology, psychiatry, sociology, or law. A lawyer can be appointed. This is the qualification. What is the disqualification? No person shall be eligible for appointment to the board. It is relating to the social workers. As any past record of, including also the magistrate, yes, any past record of violation of human rights or child rights, or has been convicted on offense involving moral turpitude. And 3, he was removed from removed or dismissed from service of central government or state government or undertaking or corporation owned or controlled by central government or state government. 4. As ever indulged in child abuse or employment of a child labor or any other violation of human rights or immoral act. Therefore, there are also other portions. The tenure is 3 years, and I am not going into other aspects. Therefore, what is the constitution of the board? And what is the qualification of the board members? What is the disqualification that I have dealt? This is under section 4. And 5 and 6 are relevant to the extent the child conflict with the law. That is a child who has committed offense with that below 18 years. Then the inquiry shall be conducted by the board. Is both 5 and 6 contemplates only that. This is the crux. 6, a slight difference is, suppose if a person is apprehended, they don't use the word arrest. Like conflict in law, like not using accused. In normal criminal law, it is used accused. Here it's a conflict with law. Here, a child has committed an offense before 18 years, but it came to light subsequently. He was apprehended later. They have used apprehended subsequently. Then also this act shall be applicable. Other laws, our IPC and other laws is not applicable. Therefore, the crucial factor is, at the time of commission of offense, whether the person was a child or not is the issue. 5 and 6 deal with that. I don't want to, for that sake of time, I want to proceed further. And the important is what is the procedure of the board. Procedure is it is not the act says. In practice, I am not aware. It shall meet at such times. That is what it says. There may not be everyday meets. That is what I understand. That is what section 7 says. Procedure, it shall meet at such times. And what is the procedure they should follow? The procedure are child friendly. This is a word used, child friendly. What is the venue? Venue is not intimidating the child, and the board does not resemble as regular courts. These are all the significant words used. It shall meet at such times. Procedure is a child-friendly procedure. Venue is not intimidating to a child. It does not resemble as regular courts. What is the quorum? 2 for final disposal, or for orders under section 18. Let me deal with later. What is 18.3? That is what it says. And the event of difference of opinion among the members of the board, in the interim or final order, the opinion of the majority shall prevail. But where there is no such majority, the opinion of the principal magistrate. I said, who is the principal magistrate? In the town, in the metropolitan city, metropolitan magistrate, and in other areas, he is a judicial magistrate. And then, what are all the constitution of the board? Qualification, disqualification, procedure. Now we want to see with what is the powers, functions, and responsibilities of the board. It is quite section 8 contains subclass 1, subclass 2, and subclass 3. Subclass 3 deals with A to M. I am not going to do that. Only a simple thing is that as I stated about the principles governing the act, it is repeated here. What they say is, the relevant thing I just want to say is, the board will, there is a directing the probation officer. You know, probation of the probation of it is also, we are aware of probation officers. Probation officers are means an officer appointed by the state probation under the Probation of Offenders Act. Therefore, directing the probation officers or if they is not available, child welfare officer, for a social investigation report within 15 days from the date of first production of child before the board. There are so many things. The adjudication is as per section 40. I am not going to deal now. Therefore, though the A to M, 8.3E is relevant in my view. There is a social investigation report. That report is to understand about the child antecedent and the family circumstances to the board to adjudicate the matter. It may be a material. Not that it is not the more than that. It is the board will direct the probation officer or child welfare officer. Child welfare officer is a child welfare committee. I will come later, and I am not going to deal with other matter. And you suppose it comes to a regular magistrate, a child, the case is produced. The magistrate should, the section 9 says, should transfer it to the board. He cannot deal with the matter relating to a child. No regular criminal court shall do that. And whenever a claim arises as to whether before a board, whether a person is a child or not, the board shall determine the same relating to the ascertain the age at section 9 read with section 94. How to ascertain the age? Section 94 says, look into school record. In the absence, look into birth registration. Otherwise, look into other scientific method like other medical tests to ascertain the age. And the most important thing is the issue relating to a person can raise. Sorry, the entire trial will be over. The person could have been punished. Still, a person can raise at any stage, even at the stage of appeal, even at the stage the Supreme Court. The word used is a claim may be raised before any court at any stage, even after final disposal, to determine the age at the time of commission of the offense. If a person is able to establish the commission of offense took place when it was a child, even if a punishment was handed down, those punishment will be set aside, will have no effect. It says, the proviso says 9(2), provided that a claim may be raised before any court and she should be recognized at any stage, even after final disposal of the case, and such a claim shall be determined in accordance with the provisions contained in this act and rules made thereunder, even if the person has ceased to be a child or before the date of commencement of the act. Section 9(3), the court finds that the person has committed an offence and was the child on the date of commission of such offence, you shall forward the child to the court for passing appropriate orders, and the sentence, if any, passed by the court shall be deemed to have no effect. Yes, I think, therefore, at any stage, even at a later stage, if it is found the sentence passed will have no effect. Then what is the procedure to be followed by the board? If a child in conflict law now is produced before the board, is apprehended by the police, and even in the police, the normal police cannot handle with a child. You should be placed under the charge of, one is a special juvenile police unit. The special juvenile police unit will be in every district, and then with three member. One is a DSP under the chairmanship of, like, it is not used about chairmanship, under DSP, not less than the post of DSP, and 2 social worker. It is the child welfare police officer is defined in section 255, and also deals under section 107 about this special juvenile police unit. Number 2 is child welfare police officer. Child welfare police officer is defined in section 218 and section 106. And it is every police station there will be police official in the rank of assistant sub-inspector and above. He should be placed in charge of the child. If a police officer apprehended, any police official apprehended a child who is in conflict with the law, it should be handed over to either to the child welfare officer or special juvenile police unit. They will in turn, they will produce the child before the board. The child cannot be placed in police lockup or jail, and they should be they should be sent to observation home. I'm not dealing with those. There are so many children's home, open shelter. These are all. They were kindly look into this. Children's home, open shelter, observation home, special home, place of safety. These are all the so many the facilities are provided under the Act for the purpose. The children can be placed in those places for child conflict with the law or child that requires care and protection. That is the children's home. If observation home is a child in conflict with the law during the inquiry by the board. After the inquiry, the child will be placed in special home or place of safety if he is found guilty, and the punishment is imposed to be retained in not in jail, in a special home or place of safety. This is how the scheme of the Act provides for. And what will happen if a child is apprehended? The word used is apprehended. As I said, the conflict with the law and apprehended, not arrest, not accused. If what will happen? It should be produced before a court within 24 hours, as in other criminal cases. And the police officer can also give a bail. If he thinks fit, he can do that. The powers is given. He can also give the police station itself bail can be granted. Or if not granted, he will be placed in an observation home till the boy is produced before the child is produced, boy or girl, but produced before the board. And if a bail is granted, bail can also be granted he will get into association with known criminal or expose the said person to moral. There's also many said, but the board can deny bail. If such event, he will be sent to observation home during the inquiry by the board. And what is then? I think I should start with section 13. If a child in conflict with the law is apprehended, it is the duty of as already said, child welfare police officer of a police station. They are the special juvenile police unit, which I said that it's a duty cast on them to inform to the parent or guardian if they can be found. And sometimes a child in conflict with the law, there may not be parent. He may be orphan. He may be abandoned child. If the child has parents, the parent, guardian, and the duty is cast on the child welfare police officer, sub-inspector, not below the rank of assistant sub-inspector. He should inform. And officer, they should do social investigation regarding the circumstances likely not be the board. The welfare officer has to give a social investigation report. That is not the inquiry by the board. It is to assist the inquiry. Child is released on bail, they will be informed. What is the inquiry? Suppose a child is what is the inquiry by the board? If a child in conflict with the law, that child in conflict with the law is a child has committed certain offense. If below 18 years committed a certain offense, maybe the offense may be petty offense, the offense may be serious offense, the offense may be heinous offense. In all those cases, the inquiry, how the inquiry is conducted, is dealt in under section 14. It dealt with by the board under 14. Orders are passed under section 17 or under 18. There are the two ways of disposing those matters. I think technically I will take, but however it is a most important aspect, I will deal with at least with the board. And when the child in conflict with the law, then what is the period of blades? 4 months and extension by 2 months. Yeah, totally in 6 months they are supposed to dispose of the cases. What will happen if they don't dispose of the cases within 6 months? The law says in the case of petty offenses, that is the offenses for which law contemplates up to 3 years, the proceedings shall stand terminated. You kindly see, this is not in other cases, but in as far as child is concerned, if the board is not supposed to complete the inquiry with 4 months. Later, 2 months, the extension is will be granted. They will take it, but if they don't do that within 6, petty offense will terminate. But serious or heinous offense, the extension will be granted by the chief judicial magistrate. Here is a magistrate. He is conducting. Is a chief judicial magistrate, higher authority. He will grant extension. Unfortunately, there is no time limit. In the case of serious offense or heinous offense, chief judicial magistrate grant extension after extension. Therefore, it will not found this a Nobel laureate that Kailash, that I forgot his. He said it will take 20 years for disposal of cases. This is how the board deal with the children. For us, I said, if it is 6 months, they will follow
the summary
proceedings. Okay.
Sir, your network is unstable. So is it possible to move to towards the window or something to get better signal? Is it possible?
Airtel, if I switch over, I am near the window.
Can you speak now, sir? We'll just check.
I think sir, is it better? Hello?
Yeah, now.
Hello?
Now better. Yeah, better, sir.
Now better, sorry. Maybe I am. Okay, I opened the window. I have the window, but I have not opened, fearing about the mosquitoes, and I will open. Okay, sorry. There is a connectivity. There is a problem with the connectivity, and yes, sir. And inquiry is conducted by the board. The section 14 deals with this inquiry is conducted by the board about that it should be the simple matter, as I already said. Given a being heard and participate, the full child will be given a full participation. But if it's a summary proceedings, if it's a serious offense, it's like a trial in summons cases as provided under the Code of Criminal Procedure. If it is a offense, then there are two provisions. If it's a heinous offense, a child below the age of 16 years, it will be disposed by the board itself. A distinction is made between the child below the 16 years, a child above the 16 years, in the case of heinous offense. If it is a child is below the age of 16 years, the child as a committed heinous offense is a child in conflict with the law, committing heinous offense, then the board will deal with those matters. In the case of who has committed heinous offense, the child is between 16 and 18 years, then preliminary assessment into heinous offense will be made by the board. The preliminary assessment should be made within a period of 3 months. The assessment is the mental and physical capacity to commit such offense, ability to understand the consequence of the offense, and only for purpose. If based on this preliminary assessment, that the preliminary assessment is a preliminary assessment is made within 3 months by the board, and for the preliminary assessment, they can take the assistance of experienced psychologists or psychosocial workers or other experts by the board. Based on the preliminary assessment, the board can treat it as a serious offense, not a heinous offense, and they can proceed themselves following the procedures in summons cases. Can dispose it. If it comes to the conclusion, it is not so. It can send it to the children's court. That is a special court constituted to deal with the children. It is a sessions court or a special court notified under this act. Therefore, if it is a heinous offense committed by the child above the age of 16, below the age of 18, in certain cases, after preliminary assessment, dispose the matter to it to the children's court. As I already said, what board can also, after inquiry, may record the finding. No offense is made out, like acquittal. It is not acquittal is not the word used. Accused is not the word used. It said not committed offense, and orders to be passed. And this is what the section 17. And suppose even after holding that charge case is not made out, this offense is not proved. Even then, if the child requires the need of care and protection, the board will refer it to the children committee with the appropriate directions. That section 18 is relating to what is section 17, held not guilty. The word used is charge. The word used not committed any offense. Not the word used. In 18, you see, it come to the conclusion that committed a petty offense or a serious offense. One, the conclusion is a petty offense or a serious offense or a heinous offense committed by the child below the age of 16 years or a heinous offense committed by child between 16 to 18, but the board, after preliminary assessment, thought it can proceed with the case. The charge is recorded the finding. The child committed these offense, either petty offense or serious offense or heinous offense, as I explained. Then the board will pass 4 types of order. One is for not 4, A to G. What to A to G? 1, 2, 3, 4, 5, 6, 7 types of the order. Allow the child to go home after advice or I may use advice or admonition. That is okay. The board may think advice or admonition is sufficient. Or what is it? B, group counseling, and C, for direct the board to direct the child to perform community service. D, the imposing fine. And E, released on probation of good conduct. And F, also released on probation of good conduct. There is some difference between those two. And G, that it is this is G alone, sending the child to it is really imprisonment. Like, it is not bad he is used imprisonment, sending child to special home. This is a child special home. There also is a maximum period, not exceeding 3 years. It may not send more than 3 years for providing reformative services, including education, skill development, counseling, behavior modification therapy, psychiatric support. This is relating to petty offense, or I said a serious offense, or a heinous offense committed by the child below 16 years, or a child heinous offense committed by a child between 16 and 18. On preliminary assessment, the board thought to continue with the inquiry. In those circumstances, these are all the possible orders that could be passed by the board. While passing these orders, all the orders A to G, the board may also pass, direct them to send to attend the school, or attend a vocational training center, attend a therapeutic center, prohibit the child from visiting a specified place, undergo a de-addiction program. And if, as I said, in the case of heinous crime, heinous offense between 16 and 18, on preliminary assessment, the board came to the conclusion it should be referred to the children's court. It will be referred to children's court. Children's court are the special court constituted under the Act. It's a court of session. The children, when the children court, they will try the matter, and they will hand it down. It is not a sentence. They don't use the word sentence. They pass a final order. The children court will pass a final order with regard to children in conflict with the law. What will be the order that will be passed is one thing. What they say, after the procedure is completed, children court may decide to release the child. Release the child on such condition as it deems fit, which includes appointment of a monitoring authority for the remainder of the prescribed term of stay. Therefore, after the inquiry, I am not giving a very offense. That too between 16 to 18 years. That too, the board thought it should go to children's court, the sessions court. The sessions court that decide to release or decide the child shall complete the remainder of his term in a jail after 21 years. That is how it is said. And in any even it's a heinous offense, the child cannot be, suppose a child involves in a murder, the child cannot be imposed the penalty of death or imprisonment for life. That is section 21. And also there is no preventive detention of a child is permissible. There is a prohibition under this act. No preventive detention. These are all the broad features of the functions of the board, constitution of the board, procedure of the board while conducting inquiry. After inquiry, how the board deals with these matters is then comes the Child Welfare Committee. Said that committee.
Sir, so your voice is breaking again. I think if you turn off the video, the connection will be better.
The Child Welfare Committee, not here. Okay, I will do.
Can you speak now, sir?
Sir, 1 minute. I will turn off. Okay. Now it is. Yeah. Sorry, sir. I did. Then Child Welfare Committee, like board is 3-member, I said. Like Child Welfare Committee consists of 5 persons appointed by the state government for every district. It consists of chairperson and 4 other members. And at least the one among the 4 members shall be a woman, and another an expert on the matters concerning children. And the qualification is no person should be appointed as member of the committee unless he has a degree in child psychology or psychiatry or law or social work or sociology or human health or education or human development or special education for developmental child, and has been actively involved in health, education or welfare activities pertaining to 7 years, and therefore or is practicing a professional with a degree in child psychology, psychiatry or law or social work. And the disqualification is as like a board. No, he could not have a past record of violation of human rights, convicted of moral turpitude. He should not have been removed or dismissed from government service. He should not have indulged in child abuse. These are all the disqualification. And in addition to board, he cannot be a part of management of a child care institution in the district. You see, there are so many child care institutions which I have mentioned. Children's home, open shelter, that I have no time to deal with each of them in detail, and observation home, special home, place of safety. And the Child Welfare Committee, the tenure is for 3 years. They will function as a bench, and like a year at least. When the final day, when they inquire into the matter, they should conduct the committee should at least meet 20 days. Here there is a compulsion. In board there is no such. They can meet as they. Sir, okay. Are you audible? Okay. The 20 days. The committee will meet, and at least there should be 3 members present at the time of final disposal of the case. If there is the majority opinion, if there is a difference of opinion, majority opinion will prevail. There is no majority, the opinion of chairperson will prevail, as in the case of board, where the magistrate opinion, the principal magistrate opinion will prevail. And the Child Welfare Committee that only takes care and protection. That only the chapter 6 deals with children in need of care and protection, and how that as soon as a child is in need of care and protection is produced before the committee by 31 says by any police officer, any public servant, Childline Service or any voluntary or non-governmental organization, child welfare officer, probation officer, any social worker or public spirited citizen, by child himself, any nurse, doctor, in a hospital or maternity home, whoever produces the any child in need of care is protection produced before the child welfare committee. They should those persons shall produce within 24 hours. Then the child welfare committee will entrust the child either in children's home or fit facility. These fit facilities defined fit under the act. Fit facility is a temporary facility provided to those child or a fit person. Fit person is decided, certified by the committee. Who are the fit person, and then they are sent to the child welfare committee, sent to these persons, and the method of holding inquiry is also provided. Another one interesting thing is surrender of children. It deals with the section 35. A parent or guardian who, for physical, emotional, and social factors beyond their control, wishes to surrender his child, shall produce the child before the committee. The 2 months time is granted to rethink. Otherwise, the child is taken care of by the child welfare committee, and it will be given for adoption if it is less than 6 years of age. If it is above 6 years of age, it will be sent to children's home by the committee for those who the surrendered child. Therefore, either surrendered child or abandoned child or orphan child, this is the method. This is how they deal with this, and I think it requires a very. You have to look into these sections. It is very. This is a broad feature of the child welfare committee. They place the children at a particular place, either on its own accord or as per the direction of the board. If suppose a child is the observation home, during the inquiry by the board, it will be placed by the board with the assistance of the child welfare committee. This the board will refer it to the child welfare committee. They will take care. They will put it in the observation home. During the inquiry, be in the board. After suppose some sort, it is not a bad punishment is used. Stay, they call it stay in a home. That is called the home is called a special home or place of safety. They will stay there, where they are given education, skill development, and other facilities. And that also deals with adoption. I am not going into deal. It is a elaborate deals with about the adoption of 3 types of child: one orphan, abandoned, or surrendered child. If it is below age of 6 years, they are given adoption. The adoption, as the detailed procedure is stated, and also it provides about the appeal procedure. I have no time there. Therefore, there is appeal is provided under section 101. Appeal is provided against the order of the board. Suppose the board says, and as I already said about the heinous offense, the board itself will decide the matter. The issue can be appealed to sessions court. Likewise, other appeals are also provided. Against the order of the children's court, also appeals are provided. Section 101 deals with the appeals. There is no appeal shall lie from an order of acquittal. Here is the word used by acquittal, but not at the main provisions. And in the appeal provision, it said banned by the board in respect of a child alleged to have an offense other than heinous offense. I said no appeal against acquittal. No second appeal shall lie from any order of the court of session. Therefore, details are dealt in the appeals. The High Court has a revisional power under section 102, and these are all the salient features of Juvenile Justice Care and Protection Act. Now I deal with, in short, Protection for FOCSO Act, Protection of Children from Sexual Offences Act 2012. And shortly, I don't want to take in detail, but here also it is very useful to refer to objects and reason. You see, it is 2012. We are party to acceded to the United Nations Convention on Child in 1992. We took 20 years to pass this law. Now I start here. Whereas class 3 of Article 15, it is an object and reason of Constitution, inter alia, empower the state to make special provision for children. And whereas the government of India has acceded on 11th December 92 to Convention on the Rights of Child adopted by the General Assembly of United Nations, which has prescribed a set of standards to be followed by all parties in securing the best interest of the child. And whereas it is necessary for the proper development of the child, that his or her right to privacy and confidentiality be protected and respected by every person by all means. And whereas it is imperative that the law operates in a manner that the best interest and well-being of the child are regarded as being of paramount importance at every stage to ensure the healthy, physical, emotional, intellectual, social development of the child. And whereas the state parties to the Convention on the Rights of the Child are required to undertake all appropriate national, bilateral, and multilateral measures to prevent the inducement or coercion of a child to engage in any unlawful sexual activity, the exploitative use of children in prostitution or other unlawful sexual practices, the exploitative use of children in pornographic performances and materials, and whereas sexual exploitation and sexual abuse of children are heinous crimes and need to be effectively addressed, this act is enacted. This is the law. Therefore, though we are a party to this United Nations Convention in 1992, we acceded to the convention. We enacted the law after 20 years. Here, just I go by the chapter 2. Who deals with the A to E, capital A to E, capital A, sexual offences against children is chapter 2. A is, I'm not going in detail, a penetrative sexual assault and punishment is provided in chapter 2, capital A. What is penetrative sexual assault is defined in section 3. It's called penetrates. Yeah, the word used, I am not going into penetrates. His penis into vagina and the mouth with the right goes on. Yeah, A. B. Inserts that any object or part of body not being the penis into the vagina, utera, and so on so goes. C. Manipulates any party of the child so as to cause penetration into vagina, so on so. 4. He applies. Therefore, he uses the word penetrates, inserts, manipulates, implies. This is penetrative sexual assault. What is the punishment? The punishment to the accused shall not be less than 10 years. That may go up to life imprisonment, along with fine. The fine, this is what is a ameliorative measure. The fine can be paid to the victim to meet the medical expenses and rehabilitation of the victim. As far as the punishment is concerned, if it is below 16 years of age, the punishment is something more. It is not less than 20 years. Earlier he said less than 10 years. If the child is less than 16 years, it will be not less than 20 years. It may extend to life imprisonment. That is, it said it shall be in imprisonment for the remainder of the natural life. This is what the law says. It is a penetrative sexual assault. Then B says aggravated penetrative. What is aggravated penetrative sexual assault? They are nothing but it is called a fence is eating the crop. Those are all the aggravated penetrative sexual assault. It deals with A to categories A to U. Category A is a police officer. I don't know what is a police officer. It says within the limits of the police station, in the premises of the station house, in the course of his duties, known as something like that. Therefore, police officer. Number 2 is a member of armed force or security force. What are all the armed force and security force? In the schedule, the armed force and security force is given. And in the schedule of the act, the armed force, there are 8 to R. The Air Force Act, Army Act, the Assam Rifles Act, it goes on. 8 to R. Those who are employed in armed for security forces, they involved in these penetrative sexual assault. It is called aggravated penetrative sexual assault. Public servant. C. D. Management or the staff of a jail, remand home, protection home. E. Management of staff, management or staff of a hospital, whether government or private. Management of staff of an educational institution or religious institution. Gang penetrative sexual assault. It goes on using deadly weapons and this penetrative assault. Whoever commits penetrative sexual assault causing grievous hurt, causing bodily harm. J. Whoever commits penetrative assault which physically incapacitate the child or make the child pregnant, so cause death, and goes on like up to U. That punishment for aggravated is the minimum punishment is less 20 years, and maximum is death, and also along with fine. The fine, there is a provision for payment of fine to the victim. And this is B, penetrative sexual assault and aggravated penetrative sexual assault. C is sexual assault, where we see penetrative sexual assault is a penetrate, inserts, manipulates, applies, is mouth and all those things. What is sexual assault is touch, mere touch, without penetration, touches. The penis and or breast of the child, it is a sexual assault. Punishment is not less than 3 years, but may extend to 5 years. But aggravated sexual assault is, as I said, all those categories. Up to, I said you here, it is one more category is added. They involved in this. It is aggravated sexual assault. It is up to V. For which the punishment is for which not less than 5 years, but which may extend to 7 years. Then E is sexual harassment. Therefore, first is penetration, 2 is touch, 3rd is use of uttering word, word, sound, 1, 2. It has for 6 part. Makes a child exhibit a body. It is not touching. So anybody repeatedly, constantly follow or watches contacts a child, threatens to use a real or fabricated depiction through electronic or film or digital media, entice such a child for pornographic purpose, all this comes under sexual harassment. The punishment is hello?
Stalin Sharma, kindly mute your voice.
The punishment is 3 years up to maximum 3 years. Maximum 3 years. No, and also fine, but there is no provision for payment of fine to the victim. And that chapter 3 deals with the pornography. How it is prohibited, and punishment is provided for pornography. And thereafter, these are all the salient features, and 1 or 2 issues. What I after 1 or 2 issues is relating to the procedure for media. There is a prohibition under section 23. So 23 section 23 has subsection 1, 2, 3, 4. But I want to read 2. No reports in any media shall disclose the identity of a child, including his name, address, photograph, family details, his school, neighborhood, or any other particulars which may lead to disclosure of identity of the child, provided the special court can give permit by what the special court permits, then it can be permitted. This is the identity is shall be concealed. Is the purpose of the act. Then the statement of recording of a child, how it has to be recorded. All these things are stated. The statement shall be recorded as far as possible by a woman police officer, not below the rank of a sub-inspector. The police officer shall not be in uniform, and no child shall be detained in police station in night for any reason. The police officer also shall ensure the identity of child is protected from public media. And also, when magistrate can also record under 164 statement, Code of Civil Criminal Procedure. At that time, even the right to presence of the advocate is prohibited. Now, no one can claim a right. And one more significant fact is about the special court are appointed to try this case, and these proceedings are held in camera. Held in camera means no one will be allowed. It is not an open court. It is a trials are conducted in camera. Child will not test before the accused, but accused can hear behind the scene what the child says, but it cannot. The accused is not permitted at the time of testifying to present before the child, like in other cases. It shall be held in a camera, and the special court. The special court shall ensure child is not called repeatedly to testify in the court, and the child court, the special court, also permit frequent breaks for the child during the trial. Either the special public prosecutor, here the appointment of special court, special public prosecutor to conduct the case, or the counsel appearing for the accused. They cannot put the question to the child directly. It should be put to the child through the special court. It is a mandate. Section 33, subclass 2. It is a mandate, and the special court shall also ensure identity of is not disclosed. These are all the and in my view special features. And one thing I forgot to tell, like this POCSO Act, I think section 1 minute. I think section 74, I think so. 1 minute in the Juvenile Justice Act. 1 minute that I will complete with this. Section, I am correct. Section 74. I will read. Prohibition on disclosure of identity of children. Also here also, whenever an inquiry is conducted before a board, here also there is a prohibition. No report in any newspaper, magazine, news sheet, audio, visual media, or other forms of communication regarding any inquiry or investigation or judicial procedures that disclose the name, address, school, or any other particular which may lead to the identification of a child in conflict with the law, or child in need of care and protection, or a child victim or a witness of a crime involved in such a matter under any other law for the time being forth, nor shall the picture of any child shall be could be published. There are also other two provisions. This is the crux of the section 74. And also there is a provision relating to that deals with the child used for begging. It is prohibited. And the kidnapping, abduction, all those things. I think I have corporal punishment. All those things are dealt under Juvenile Justice Act. It is a very comprehensive act. I know it can't be done in a short time. I have taken more than 1.5 hours, nearly 1.5 hours. And I have taken you broadly through this law to understand, so that you can read yourself with this understanding. Therefore, it is the nowhere it used accused, no child in conflict with the law. Nowhere it used convicted, even acquittal at the time of appeal, not at the time of inquiry. It is not used the word even acquittal. It says they uses different word, and therefore I have done. I try to do. It requires a passionate reading. In fact, it's not a Zoom directly. It has to be passionately. It has to be read along with every student, everyone, or every lawyer should have a copy of the act. Both should read together. Then only we have to understand the seriousness, or the enactment. As I said, the enactment has various components. It deals with care and protection, and it deals with the child in conflict with the law, and deals with care and protection parts also. Deals with about the orphan children, abandoned children, surrendered children. They are put in the children homes, and also provided for adoption if it is a child is below 6 years of age, in the case of orphan, abandoned, or surrendered child. And I think I have done some justice to the subject. Thank you for listening to me for 1.5 hours.
So you can turn on your video now, sir. So thank you so much for your time and commitment to providing your insights on this subject in our forum, sir. So if participants have any questions or any comments, you can unmute yourself and share them or ask. Sir, I have one question that I wanted to ask. You said that you mainly mentioned that though India ratified UNCRC in 1992, it took so many years to bring about legislation for children, that is JJ Act and POCSO. So why do you think this legislative delay is happening? And how can this be reduced?
Sir, in the case of scheduled caste, it is still worse. Like SC/ST, Atrocity Prevention Act. It came after 50 years, nearly 50 years. It's unfortunate. Even in the case of children, it took such a long. In the case of disabled children, we are 42 Beijing Conference in 95. The law brought only in 2006. Therefore, we are. In my view, we are weak in our democracies. These measures, or in Western countries, have come very, very, very long back. Came. Like these Juvenile Justice Act or POCSO Act, or the right of disabled children. If you go even Western countries, without ramp, you can't see any public office. Even now, do you have any ramp? Even all the court, district court, can a person with a disability can go to court now? Can you go in a wheelchair? That is why
very difficult.
That is why I am saying our democracy, we can our sensitization. We are not sensitized to the subject. I have not the word used, sensitization. The purpose, induction training, they call it. Even for the principal magistrate in the board, who should be given induction training about the children's right. Otherwise, they will treat like an ordinary criminal court. They will do that. It is a tough job. When you gave me opportunity to go through this legislation, because I did not. It was not legislated when I was a lawyer. when I was a law student, sorry, even when I was a lawyer also, Juvenile Justice Act, it came. But at the 2000, when it is somewhat, it can be used, I became a judge. And this 2012 is at the fake end of my retire. I retired in 16, in between my career. Therefore, just before Nirbhaya, this we are not subsequent to Nirbhaya. I think just before Nirbhaya 2012, this act came. Of course, the lack of sensitivity. We can say so many. That is what three other instances, like disabled, like also this LGBT community. Still, we have a problem in LGBT community. So like even women's rights is a right property for women. Only in 2005 we brought a law giving equal right to women, Hindu Succession Act.
Yes, sir. Yes.
Therefore, why? How can you explain in 21st century why women are not given equal right in the property? Only when it becomes a reality that there are no more into undivided family, the law has come, in my view. Fortunate. Or everyone has to come with some explanation. Everyone who is listening here, let them come with some explanation.
Yes, sir.
At least we are happy. At least it has come now. You have done some. It is a sensitization of the issue. It is like an induction training. You have a debate, so that if you go through this act, it will take at least a week time to look into 112 sections, 112 sections. Juvenile Justice Act is a very elaborate law dealing with every aspect of the child. Child in conflict with the law, as well as child care and protection.
Thank you, sir. Thank you so much.
Kritika, you're on mute.
Am I audible now?
Yeah, you're audible now.
Thank you, sir,
Oh, yes.
for your enlightened presentation today, and your emphasis on the Constitution, which lays the foundation for all child-related legislation, starting from Juvenile Justice Act, Protection of Child from Sexual Offences Act, and you also included the Commission for Protection of Child Rights Act. So we are very grateful for the detailed interpretations and the practical insights you shared today, which will be very helpful for us to understanding the importance of these laws and the need for dedicated bodies, like especially you explained in a very detailed manner, like juvenile justice board, child courts, and the importance of child welfare committees. Thank you so much, sir. I extend my deepest thanks for your invaluable contribution to this webinar. Thank you.
Thank you.
So,
and sir, unfortunately I am not in Chennai.
oh, okay.
I am with my family in some distant place. Fortunately, that is why I am. Fortunately, the 4G is available, and the Wi-Fi is weak. Therefore, I use this 4G. And if it is in Chennai, I think it is more audible. It could have been a better here.
Yes, sir, of course. But that's all right.
I should have I put off the video. At the earliest point.
Much earlier. Yes. No, that's all right, sir. So anyway, thank you so much for your contributions.
That is why when you said I informed that it's not the simple task. I said it's when you interacted with me, I told you the subject is such a heavy subject.
Yes, sir.
Okay.
So So with that, we are coming to the end of webinar 4 of our Child Rights and Wellbeing webinar series by Law Comrade. So we will keep you posted about our next webinar in our WhatsApp group and via email. So we would love your participation throughout the series. So thank you so much, participants, for patiently listening to our speech today. And thank you so much, sir, for being here with us. Even despite your family commitments, you are here for us. So we thank you wholeheartedly. So with that, we come to the end of the session. So thank you so much, everyone. Good evening.
Thank you.